Is it your intention to plead guilty to, so would it be, you just take them up to the podium, it's fine. Thank you. So it's gonna be an added 4 and 5, Mr. Sneed, count?
Yes, Your Honor.
All right, is it your intention to plead guilty to an added count 4, attempted R&O and disorderly, attempted R&O, and count 5, disorderly conduct? So is it your intention to plead guilty to those 2 counts?
Yes, it is, Your Honor.
Okay, are you satisfied with Mr. Murphy as your attorney and the advice that he has given you?
I am.
All right, and is attempted R&O carries a maximum penalty of up to 1 year in jail, and disorderly conduct up to 93 days in jail. Do you understand that?
Yes, I do.
Okay, doesn't mean you're gonna get that. It just carries that maximum penalty. Do you understand that?
I do, Your Honor.
Okay, so other than the plea agreement that was placed on the form of record, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Steen?
Yes, Your Honor.
Mr. Murphy?
Yes, Your Honor.
And Ms. Smith, as far as you're aware, is that correct?
Yes, Your Honor.
All right, so ma'am, if a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, ma'am?
Yes, I do, Your Honor.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, I do not.
All right. How do you wish to plead to the charge on file number 24-21806, count 4, that on or about February 18th of 2024 in the city of Adrian in the county of Lenawee, that you did commit the offense of attempted R&O? Guilty or not guilty?
Guilty.
And that on the same date and time in the city of Adrian in the county of Lenawee, that you did commit the offense of count 5, disorderly conduct? Guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No, Your Honor.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr. Murphy?
No, Your Honor.
All right. Other than the agreement that was placed on the record, Ms. Smith, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, he has not.
Is it your own choice to plead guilty to these counts?
Yes, it is, Your Honor.
All right. So, Ms. Smith, on February 16th of 2024, were you in the city of Adrian in the county of Lenawee?
I was, Your Honor.
Okay. And at that time, did you come in contact with Officer Gentner, Jonathan Gentner from the Adrian Police Department?
Yes, I believe so, yes.
Okay, maybe you didn't know his name, but was it an Adrian Police Department police officer?
Yes, ma'am.
And he was wearing his uniform
Yes, he was.
and he had a badge?
He did, yes, ma'am.
Okay, so you knew he was an Adrian police officer.
Yes,
All right, and did he try to arrest you?
yes, he did.
Okay, so the charge would involve, did you push him, pull him, kick him, pinch him, run away from him, pull your wrists away from him, spit on him, or just disobey orders, not put your hands in a handcuff? Can you tell me how you attempted to resist arrest?
I moved my arm away because I just moved my arm away because I was trying to medical issue.
So hold on one second, you're kind of breaking
Just
up,
wasn't
Ms. Smith.
understanding. So I didn't know what was going on. My
Okay, so you
apologies.
you kind of broke up a little bit. So when he was trying to handcuff you, you moved your hand away?
Yes,
All right, Mr. Sneed, you satisfied?
Yes, thank you.
Okay, now, you're also pleading to a disorderly conduct. So was there a Dale Wendell Meek there at the time or a Caitlin Marie Burns?
yes,
And Mr. Sneed, do we still require it to be that there was an altercation or just an argument loud enough that a third party could have heard?
Yeah, the latter
or
is fine.
disorder-
Judge.
Okay, so were you guys arguing and carrying on a little bit?
yes, we were, ma'am.
All right, would you agree that someone on the street, other than the people involved in the altercation, could have heard that and would have been disorderly or disturbing the peace in some way?
I agree with that, Your Honor.
Okay, Mr. Sneed, are you satisfied?
Yes, thank you, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, Your Honor.
Mr. Murphy?
Yes, Your Honor.
All right, I accept the pleas that they have been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I am going to refer this matter to the district court probation department for a pre-sentence investigation. So, Ms. Smith, not tomorrow, but next Thursday, which would be October 24. I need you to report to the district court probation department between 8 and 10 in the morning, okay?
Okay,
And you're gonna meet with Mr. Mike McCarron, and he's gonna interview you. Be truthful about the events that occurred. Be truthful with him about your background. He's going to prepare a pre-sentence report. We will provide a copy of that to Mr. Murphy, and Mr. Murphy will reach out to you and review that with you. And then we will see you back here for sentencing on December 13 at 8:15 in the morning. And ma'am, I don't want your address on the record, but are you still in apartment 4?
no, ma'am, I'm at
Okay.
27.
No, I don't want it on the record.
I just listened to you.
No. So Miss Adams, I'm going to put you in a break. Do you have her new updated address, Mr. Murphy?
Yes, we do, Your Honor. We can provide that to the court.
All right. So if you could send that to Miss Adams to mail out the notice of hearing. So write it
Still on
down.
Carson
though.
Highway, right, Ms. Smith?
What'd you say, Mr. Murphy?
You're still on Carson Highway?
Yes, sir.
Okay, yep.
All right. So write it down, Miss Smith, December 13 at 8:15, and then next Thursday, report to the probation department between 8 and 10, okay?
Okay.
All right.
Let's
You
go
want to
back
appear
to
in
Zoom.
person or via Zoom?
It doesn't matter to me. Person's fine. Just I
Okay.
had a hiccup today.
Okay. So we'll see you back in person. Thank you.
Thank you. You have a good day.
You too.
Thank you, Your Honor. Thank you, Ms. Smith. Have a good day.
Thank you, Mr. Murphy. Bye.
Mr. Armour?
Yeah,
Okay, why don't you come up to the podium with your attorney?
all right. How you doing today, Your Honor?
I am good. How you doing?
Trying to make it.
Aren't we all? All right, so this is in the matter of the people of the state of Michigan versus Mario Cornelius Armour, file number 23-21339FH. I have Rhonda Underwood appearing on behalf of Mr. Armour, and I have Isaac Sneed appearing on behalf of the people. I do have a note in here that no, we're waiting on independent forensic. So were we waiting on an independent forensic?
We did, and we received those results, Your Honor. Thank you.
Okay, and are we doing anything with that today?
No,
Okay, so this is the date and time set for pretrial. We do have fingerprints, so that's awesome. So how would you like to proceed today, Miss Underwood?
Your Honor, the offer tendered by Ms. McClure is that Mr. Armour would plead as charged to count 1, count 2, and the habituals would be dismissed, is my understanding, Your Honor. And also, I would be requesting a COBS to the low end of the guidelines on this case, Your Honor.
All right, Mr. Sneed, does that appear to be a correct reflection of the plea offer in this file?
Yes, it is. Thank you, Your Honor.
All right, and your client wishes to avail himself of the plea offer?
He does, Your Honor.
All right, so Mr. Armour, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. Now, Mr. Armour, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead guilty to count 1 and count 2, both of which are assault of a prison
No,
employee?
count 1, Your Honor.
Just count 1? Oh, I'm sorry. I'm sorry. To plead guilty to count 1, assault of a prison employee, that carries a maximum penalty of up to 5 years in prison and or a $2,500 fine, with the count 2 being dismissed, as well as your habitual offender 4th degree. So is it your intention to plead guilty to that count?
Yes.
And then Ms. Underwood's asking for a COBS to the low end of the guidelines, and I will do that. So is it your intention to plead guilty then?
Yeah.
Now, you're currently incarcerated, so you do understand that any sentence you serve on my case will stack to the sentence you're currently serving.
Yeah, I'm already past my ERD on the case.
Okay. And you don't have anything else hanging out there? No? Good.
Just parole board flops.
Okay, okay. So you're satisfied with Ms. Underwood as your attorney?
Yeah.
Okay. Now, other than the COBS to the low end of the guidelines, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence other than that with the court. Ms. Underwood, is that correct?
It is correct, Your Honor.
All right. Is that correct as far as you're aware, Mr. Sneed?
Yes, Your Honor.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise, be appealable if you were convicted at trial? Do you understand that?
Yeah.
Okay. If you are not a citizen, do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? I might have already said that, but if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
Nope.
All right. How do you wish to plead to the charge that on or about December 17th of 2021? Is this a 2021 file? Offense date?
It's an old file, Your Honor.
Okay, that you were in, it says Lenawee County, but I'm gonna guess Gus Harrison facility, and that is Madison Township. So that's not on the felony information, Mr. Steen, in Madison Township in the county of Lenawee, that you did commit the offense of assault of a prison employee, guilty or not
Yeah,
guilty?
guilty.
Okay, and has anyone made any threats or promises to you to induce you to plead guilty to this
No.
charge? Do you understand if I accept the plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yeah.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Mr. Steen?
No, Your Honor.
Has your attorney, other than the low end of the guidelines, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
All right, is it your own choice to plead guilty?
Yeah.
All right, so Mr. Armour, back on December 17th of 2021, were you in Madison Township in the county of Lenawee at the Gus Harrison facility?
Yeah.
All right, and at that time, you were lawfully incarcerated there,
Yeah.
correct? And there was a Jocelyn Walsh Horn who was employed there, is that correct?
Yeah.
Was she a CO?
Yeah.
Okay, and at some point you assaulted her, you know, did you touch her, push her, spit on her, throw food at her, what happened?
Yeah, I think I kicked her out the chair.
You kicked her out of a chair?
Yeah.
Okay, and you didn't have permission to do that?
No.
Okay, and you would agree that's assaultive behavior?
Yeah.
Okay, and Mr. Steen?
People are satisfied, Judge. Thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
Mr. Steen?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he does have competent counsel. Other than the COBS agreement, this court has made no other agreement regarding the possibility of the plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Underwood, you are available December 13.
That's fine, Your
All
Honor.
right, I will set this for sentencing on December 13 at 8:15 in the morning. Where are you currently staying?
Back at Gus Harrison.
You're back at Gus Harrison, so you're close. Do you want to appear via Zoom or in person?
I'll appear in person.
All right, so I'll mark down in person. So someone from MDOC is going to get a hold of you and update your last pre-sentence report and get information on this one. Be truthful with them about your background, what's going on at MDOC and this offense. We'll get a copy to Miss Underwood. Miss Underwood's really good about getting in and out of MDOC to meet with people. But like I have one facility that's locked down today and nobody can get into it. So if she can't get in to see you in advance, she will meet with you the morning of and review that with you. And we'll see you back December 13 at 8:15 in the morning. All right.
Okay, yeah.
It's independent. Okay. So we don't need to put an order on for the independent forensic, correct?
I don't think so.
I can't hear you because I'm deaf. Okay. So they don't have to release an independent either.
Okay.
Right?
Hmm?
You can, when you do an independent forensic, you also don't need to release those results to the
No.
people. So I don't think an order for independent has to go on the record. I'm not, but if it is, Mr. Sneed, did you receive a copy of the independent forensic?
Let me review the file, Your Honor.
I don't think you're required to, but I don't know.
Our file doesn't show anything regarding the forensic.
It's kind of like doing a private
This
policy.
year.
So, okay, if we need to put something on the record, we could do it. All right, you're all set. So thank you, Mr. Armour. You have a good day. You too. Stay out of trouble.
Yeah, I'm trying to.
Don't keep stacking these up.
Yeah.
Thank you, gentlemen.
Thanks.
All right. All right. Okay, let's see, I got jail windows. I have a gentleman at the jail. What's your name, please, in room 5?
Castro Oliveira.
Say that one more time again for me.
Castro Oliveira.
And I think I lost Mr. Daggermer goes in. Do you know how, can you text Mr. Daggermer goes in?
I will, once I get back, Your Honor.
Okay, will you let him know I have Mr. Oliveras?
Yep,
Do you have anything else, Brenda?
I think I do. I have a number of things with you.
Are you going back to Judge Olsaver now?
No, I'm going back to get back on with you.
Well, he can let you back. Okay, I got Mr. Glazier. Do I have Mr. Haybecker? Oh, Mr. Haybecker, you want to come up to the podium? All right, so Mr. Oliveras, just hang out for a minute, all right? Okay. All right, so let me get all your files. So, Miss Adams, I need Darren Coast to maybe, hold on. Maybe not. Maybe yes. Maybe not, I don't know. All right, this is in the matter of the people of the state of Michigan versus Anthony Scott Haybecker. I found number 24-21817 FH, 24-21818 FH. I have 24-21819 FH. All of those files are set for pretrial. And then I have file number 23-51303 PP, which is set for pretrial today. And that is evidently a motion to set aside the PPO. Okay, so Mr. John Glazier appears on behalf of Mr. Haybecker. I have Isaac Sneed appearing on behalf of the people. So I have a couple things. I have a letter dated October 11th of 2024 from, I don't know, I can't read the signature, Cora Gibson maybe, through the 2A District Court of Lenawee County, stating that Mr. Haybecker was placed on bond conditions on July 18th of 23, including no contact with victims, no weapons, no keys to home. He failed to appear for court on August 1 of 23. A warrant was requested. On August 8th, he failed to appear. A bench warrant remained in place. Let's see, September 15th, the warrant was canceled when he was lodged at the county jail. On December 17th of 23, the victim received a call from the jail, and the defendant allegedly made contact with the victim. All communication privileges from the jail were revoked except counsel by district court. On April 26, bond conditions were amended to include GPS tether, not to be within 100 yards of the victim's residence. On May 3rd of 24, bond conditions were amended to include not to be in Lenawee County other than for court, and defendant was bound over to the circuit court for arraignment on May 17th. So I got that. And I got 2 copies of that. I have from Darren Coast, September 23rd of 2024. Mr. Coast is our pretrial services coordinator for cases that are moved up to circuit court. And that one states that Mr. Haybecker has been on GPS tether since April 26th. And to date, the tether is active with no reported violation since he has had it on. Mr. Mawad no longer represents him on the PPO file, so he is pro per on that one at this point. So, Mr. Glazier, with all that being said and placed on the record, how do you wish to proceed today on behalf of Mr. Haybecker?
Your Honor, I talked with Ms. Meir and I thought she was coming up to court. I don't know. I think she wanted to be involved in this.
Mr. Steen, you raised your hand.
Yeah, sorry, Your Honor. Miss McClure is on her way into the courtroom. I believe that there's also a victim that may be in attendance today as well. So if we could just pause this matter briefly, should be entering the courtroom here in a moment.
Okay, so Mr. Haybecker, you just want to sit down right behind you next to Mr. Dagger-Margosian, and we will pause this for a minute. Sit down. All right, Mr. Dagger-Margosian, I have Mr. Castro, and I am going to, oh, well, I got Miss Phoebe McClure, but hold on one second, because I have can you stay for just a moment, Ms. McClure?
Yeah.
Okay, because I'm going to go back to Mr. Haybeck, or to Mr. Oliveris. So hold on a second. I have a gentleman at the jail. It's not connected to audio. So I'm gonna send him a chat. And Mr. Degermark goes in. I've got Mr. Oliveris.
Gentlemen, the speaking, but I was actually looking for this clear on a different match. I don't know what order you want to use.
Okay, so Mr. Degermark goes in is going to need to speak with you, Mr. Oliveris. He also needs to speak with the prosecutor. So we're gonna hold off on you for a minute, and I have another gentleman in the jail room 6. What's your name?
Alphonse Edwards.
All right, can you take care of him?
Again, if I can talk. about
Yeah, so my beautiful in the back room. All right, so gentlemen, hold on just a moment. Okay, so now we're back on Haybecker. So, Mr. Haybecker, come on back up to the podium. So Ms. McClure, I had received like reports from district court. I've never seen those before, but I did, and I reviewed those, but they're old. And
Reports from district court.
It's old stuff. I don't know why they sent it up.
Okay.
But I also have a report from Darren Coast that to date, Mr. Haybecker's tether is active and he's had no reported violations. I don't know why they sent me that. Maybe I wasn't supposed to. I did put it on the record.
I don't know. That's odd.
Oh. But anyway,
What was the last thing while I was reading that? I'm sorry.
so Mr. Coast, pretrial services also included an updated report, and he stated since he's been placed on tether since April 26th, that he's remained active on it and no reported violations.
I will want to do a bond review today, when the court thinks it's appropriate, but I don't know if we want to pre-trial the case first.
Okay, well, anyway, so hold on.
Yeah.
So Mr. Glazier, how did you wish to proceed with Mr. Haybecker today?
Which charge are we talking about, Your Honor? On the criminal charges here?
Yeah, yeah.
Yeah, I don't represent him on the PPO. But on the criminal charges, Your Honor, we're gonna ask to set another pretrial, but I would like to have a in-person meeting between me and you and Ms. I keep saying Mirror, but it's not Mirror anymore.
It's okay. We had talked about doing a bench conference, Judge.
And
Okay,
I'd like to do that on maybe a different day.
well, I don't have time to do it today, so.
Yeah, I'd like to do it in person over there at some point.
Okay, so that your staff can reach out to Miss Adams and arrange for that.
I can send an email this afternoon.
Okay, so Miss McClure she'll send out an email this afternoon. All right, so we'll set a bench conference and on the 3 criminal files. So Mr. Glazier, I am going to have to rearraign him for court appointed counsel on the violation of probation because Mr. Muwad's no longer on the file. And I don't know if he has.
Just gave feedback.
Yeah, Mr. Oliveris, I don't know, I'm getting, oh, Rhonda, go, I'm gonna mute you because I'm getting feedback from you, because Michael.
Yeah.
She just gave him a side eye. Okay, so I will have to arraign him and offer court appointed counsel if he can't afford to hire an attorney on the violation of the PPO. So just let you know. All right, so you're asking for a bench conference and another pretrial, Mr. Haybecker. Now, Ms. McClure wants to address bond conditions.
I do.
So, are you ready to do that, Mr. Glazier?
As ready as I'm ever gonna be, Your Honor, yes.
Ms. McClure?
Judge, at this time, I would be asking for a remand of his bond, actually, not just a bond condition review. And I think the court has some of the background as it relates to his bond that he was released only due to medical from the jail. Otherwise, he was being held on a fairly substantial bond that we still believe is necessary in this case. As of last night and this morning, I received some information from Ms. Haybecker and a family member of hers that Mr. Haybecker was posting extensively and erratically on Facebook and called out her daughter and made references to Ms. Haybecker personally. It's along the lines of what the original allegations in this case were. I believe in district court, we had bond conditions that he not have any access to social media. But if that never came up to circuit court, obviously we can't violate him at this time on that. But I do think it's a violation in that he's called out the victim and her daughter, at least by name. It's, again, it's along the lines of the underlying charges in this case, but it's also along the lines of what we spoke about last time, and the fact that Mr. Juan had to get off the case, that he's becoming increasingly erratic with the type of behaviors that we saw when the charges were initially issued. We fear not only for the safety of the community, but for the safety of the victim in this case. And we do believe a bond remand is appropriate at this time, given those posts.
All right. All right, so Mr. Glazier, Mr. Haybecker is charged with aggravated stalking on one file, aggravated stalking, unlawful posting a message with cyberbullying on another file, and aggravated stalking again on another file. And so the allegations Ms. McClure is making, which she probably could verify or show proof of today, or at least some evidence of, is that he is again posting on social media in a threatening or bullying way. So she's asking for him to be remanded.
Yes, I understand that, Your Honor. I guess I didn't completely understand until just now what Miss McClure, she told me about this morning, but apparently this is not something allegation wise. I'm not sure whether the allegations are true at this point or not. But at least from what I understand she's saying is that he is posting, not contacting her directly. I don't know if he had a bond condition that he couldn't have social media or couldn't post, but it sounds to me it would be, even if Miss Mears' allegations are true, that it's something that the alleged victim in this case would have to get onto his Facebook in order to see. And I don't know if that's a violation of his bond condition at this point, but it doesn't sound like even the allegations are that he's directly contacting her. So we would oppose.
So on file number 24-21818FH, he's charged with cyberbullying for posting messages and statements on social media. So do you have those?
I do have all the messages I can forward to both the court and Mr. Glazier.
Do you want to screen share?
I can do, well, I don't know if I can screen share, but I can forward an email.
Okay, you can.
And in addition, or just to clarify, someone that made Miss Bannon aware of the messages, and she had her ex-husband look them up because they had her daughter's name in them. So that's how she didn't go onto his page and seek that out, obviously. But I can forward them, yes. John, what email do you want me to forward to?
John Glazier PC at gmail.com.
Okay, there's gonna be 2 emails. I think I put you in the first one, Judge. Sorry if I didn't.
Please don't put my email out there.
What?
Don't say my email out loud.
No, but
I got it.
I don't remember.
I got it.
Okay, I sent them to you or not.
All right.
Question, I just interrupted here too.
It's not her phone number or anything. There's a phone number, I don't know.
I don't know whose phone number that is.
So, Ms. McClure, just, Ms. Bowles, the reference, okay. And then I'm not seeing, I'm seeing language, but am I missing threats? Are there threats? Or it's just
Just
mentioning?
threats, it's just the mentioning,
Okay.
correct, yeah. But
Yeah.
obviously, she takes them in a threatening manner,
Obviously.
considering the full circumstances
Yeah,
of the case.
yeah. Alright.
Your Honor, I've read them. I don't think they're threatening. I don't know what he was prohibited from doing to begin with. This is obviously something that's posted that she would have to somehow get on or to get those messages. Obviously, the court could go forward and tell my client that he can't even post or get on email or anything at that point. But I don't see anything threatening in it. And again, it's probably something my client shouldn't post at all anyway. And if you want to put a order going forward that he can't use the internet at all or something of that sort, I guess we would understand that.
And I appreciate Mr. Glazer acknowledging that it's something that shouldn't be posted. It's really when you take it in the context of the whole case and what Ms. Vannon's been put through is what does make it feel inherently threatening and harassing towards her, which is kind of the whole purpose of these charges.
And I would have a different view, Your Honor, if he was actually contacting her directly. There's some serious problems that we need to take care of. That's why I want to meet with the court in person at the earliest with Ms. Meir and I keep saying Meir, at the earliest possible availability.
Ms. Adams, today or tomorrow, do I have 10 minutes to meet with Mr. Glazer, Ms. McClure? I mean, I got,
When Mr. Hendecker was in jail, he did send mail directly to Ms. Bannon. That was one of the reasons why a bond review was denied at that time. And again, just bringing that up to say the only reason he was released was because of a medical issue that he had.
Yeah, I know.
himself.
all right,
We've had no issue with the tether for over 7 months now.
okay, hold on.
Or Judge, if you want to do it before your evidentiary hearing at 1:30 today?
Is our restitution hearing going at 11? Mr. Deckerman goes in.
Yeah, it should be, I think it should be brief though.
How about 11 o'clock? Can you guys come back at 11 o'clock?
I should be able to get down there by 11, yeah.
Okay, so
I have
I'm
one-
gonna,
I have one other case with you, Your Honor, this morning, and then I'll come down after that.
all right, so I'm gonna table all this until 11 o'clock. When I come back, Mr. Haybecker, you stay in the courtroom. You can use the restroom, but not to leave the court floor, okay? All right, thank you.
Thank you, Your Honor. I'll be down there at 11, but I still got one more I got to do with you.
I know, who is it? Heatherly?
It looks like it's Rodriguez. Maria Rodriguez.
Yeah, all right, I'll call the jail for her.
All right.
Hold on. Okay, so we've got, where's Mr.? I'm gonna close the breakout room and bring him back. Hey, this is Judge Ann Simone. I am ready for Maria Rodriguez.
Good.
All right, thank you.
We'll get her going.
Thank you. All right, okay. So we're gonna do Mr. Edwards.
Yes.
All right, in the matter of the people of the state of Michigan versus Alphonse Eugene Edwards. Did you need to meet with Ms. McClure?
I do. I'm gonna talk with her in the other, no, not on this case.
Okay.
Okay, 5 minutes. Eugene Edwards, file number 24-21995 FH. This is the date and time set for arraignment in this matter. Do you waive the reading of the felony information?
Yes,
Have you received a copy of the prosecutor's request for discovery and witness list?
yes.
All right, and how would you like to proceed today?
Your Honor, at this time, I'd like to schedule this for a pretrial for investigative purposes.
You're gonna waive the reading?
Yes, Your Honor.
How far out?
2 weeks.
2 weeks? Ugh. November 13. If you resolve it, you can bring them in on any day but a Wednesday.
Me,
I'm November 13 or 20.
13th is fine.
All right, and if there's a resolution, you want to give us a call, I will get them in right away. Okay, so I'll enter a plea of not guilty on behalf of Mr. Edwards. I will set this for a pretrial November 13, Mr. Edwards at 8:30. But Mr. Dagamar goes in, if he reaches a resolution you decide to avail yourself of, he can schedule that in sooner, okay? Mr. Edwards, can you hear me?
Oh, yes, all right.
Do you have any questions?
No.
Okay, all right, we'll see you back on November 13th at 8:30, if not sooner. Thank you, Mr. Edwards. Miss Underwood, Mr. Waltice is in my waiting room and I've let him in. So you need just a moment to talk to Miss McClure.
Yeah, and then I'll be back for.
Okay, do we have any others that? Okay. All right, hold on, Mr. Waltice.
Okay.
I'm sorry, I'm bugging you again. So I'm actually ready for Shannon Heatherly, Maria Rodriguez, and Aaron Lindeman.
Heatherly Rodriguez.
Yeah,
And Lindeman. This is Ramsel, right?
yeah,
Okay.
Heatherly Rodriguez and Lindeman.
Gotcha.
All right, thank you.
Yeah, bye.
Bye. Okay, so Ms. Underwood, you with me?
Yes, Your Honor.
Okay, so in the matter of the people of the state of Michigan versus Stephen Richard Woltice, did I pronounce it right? I think I did.
Yes,
Yep,
thank you.
Woltice. File number 24-21734 FH, 24-21938 FH, and 24-21939 FH. I have Rhonda Underwood appearing on behalf of Mr. Woltice. And I have Isaac Sneed appearing on behalf of the people. This is date time set for a pretrial conference on all three files. Ms. Underwood, how would you like to proceed?
Your Honor, I think as to the pretrial, we would like a brief adjournment, not long. And also, we wish to be heard on the issue of bond conditions, Your Honor.
Right, so my next available pretrial is November 13, but obviously if there's a resolution of some sort, you can have them brought in sooner. So November 13 at 8:30 in the morning. And you can do the stip in order to adjourn, and Mr. Sneed, can she sign your name with permission?
Yes, Your Honor.
All right, and now you want to address bond.
Yes, Your Honor. I discussed this with Mr. Sneed yesterday. The parties concerning the domestic, Your Honor, have finally vacated Mr. Waltice's home. I don't believe they're even in the area anymore. And if someone believes they are, correct me, but I don't believe they are. Mr. Wolthius would very much like be allowed to move back into his house, Your Honor. They've probably taken everything that wasn't nailed down, but he would like to get back into his house and start getting his life back together, Your Honor. I know Mr. Coast contacted me about that, and I would very much, I think with Mr. Wolthius reporting to Mr. Coast, I think it could work out very well for everybody, Your Honor.
Okay. Mr. Sneed, if we can verify they're no longer in his home, can he move back to his house?
I would have no objection to that, Your Honor.
Okay, so Ms. Underwood, if we can amend the bond conditions to allow him to return back to the residence. As long, once the residence is verified to be vacated by the victims in this case.
And, Your Honor, that would mean that there are no restrictions to the tether up in Kalamazoo, where he's currently residing. So that would mean that those restrictions would also.
What were the restrictions on the tether, Mr. Coast?
Judge, right now he's got a tether where he's residing with his father over in Kalamazoo. He does his residence is in Tecumseh. I can verify this morning if the victim has since moved out. I believe she has.
Is he in Tecumseh or Clinton?
It's actually Tecumseh.
All right, so I have a house number 316. Is that the house number for him? What's the house number of your house, Mr. Wolthius, that you want to move back to? Just the numbers.
501.
Correct.
Okay. All right, so Miss Adams will need that address to amend the bond conditions if you can send it to her, Mr. Coast.
I will, Judge.
All right, so we will amend the bond conditions to allow him to return to his home. But still no contact. You understand, Mr. Wolthius?
Yes.
Okay.
And Judge, the tether to remain in place then?
The what?
The tethers to remain in place.
Was the purpose of the tether just to make sure there was no contact of those people moved out of the county? Are they?
They're in Missouri, Your Honor.
And that is my understanding too, Judge, that they did leave the state.
Mr. Sneed, in light of that, any objection to removing the tether with the no contact in place and not to leave the state?
No objection, Your Honor.
All right, so we will remove the tether and understand, Mr. Wolthius, there is a no contact order in place and you're not to leave the state without permission of Mr. Coast, all right?
Yes, Your Honor.
All right, so we will amend that paperwork and you'll need to, where does he need to go to get the tether removed?
Yep, Steve, what I'm going to do is I'm going to send JSG a message that you could return the tether, so you could return that today. Prior to you going back to Murray Street, though, give me a call, because what I'm going to do is I'm going to verify with Tecumseh PD that they have since moved out. And then once that happens, then you could go back to the residence, but you could return that tether at any time.
Okay.
All right, perfect. All right, we'll see you back then on November 13th at 8:30. Thank you.
Thank you.
All right, so Mr. Olivares, bear with us for just a moment. Maria Rodriguez. Mr. Glazier is on Miss Rodriguez. So on the matter of the people of the state of Michigan versus Maria Rebecca Rodriguez, file number 24-21897FH. I have John Glazier appearing on behalf of Miss Rodriguez. I have Isaac Sneed appearing on behalf of the people. So we have a couple things going on. One, I have a contempt of court because Miss Rodriguez failed a drug test 3 times a week as ordered and has not tested since June of 2024. And so we issued that motion affidavit and bench warrant and set bond in the amount of $25,000. So we are also set for pretrial. I think she also failed to appear for the September 18th pretrial. Is that correct, Ms. Adams? I think so, Ms. Rodriguez.
That's correct. And then you adjourned it. I don't know the reasoning.
Yeah, so because she was represented by Mr. Glazier, so we wanted to get Mr. Glazier here. She also failed to appear on September 18th of 2024 for her pretrial, and there should be a contempt of court paperwork for that. So Mr. Glazier, you represent Ms. Rodriguez. Let's see. So how do you wish to proceed today?
Let me talk to her for just a brief moment, Your Honor.
All right, so Ms. Rodriguez, I am going to open a breakout room. Give me just a moment. And you are in Zoom. All right, and Mr. Glazier, go ahead and join that breakout room. All right, so Miss Underwood, I still have you. What are you here for? Yeah, so some attorneys go there first, some come here first, and then we rotate. So if you're not lucky, you get the second rotation. All right, so Miss Underwood, I have called the jail for Miss Heatherly. I haven't put her in the room yet.
Your Honor?
Yes.
Mr. Waltice, that bond's being changed on all 3 files, right?
Yes.
Okay, thank you.
All right, I don't have Mr. Lindeman. Okay, so everybody is in jail, so I'm just waiting for the jail. Evidently.
Your Honor, I'm Mr. Robinson.
Yeah.
What happened with Mr. Robinson?
Well, they had a Zoom room set up, but then they wouldn't bring him in because he's quarantined. So I set it for November 13th at 8:30 in the morning.
November 13th. Thank you.
At 8:30. So we are going to take like a 3-minute recess. We're going to take like a 3-minute recess. We'll be right back.
Thank you.
What'd you mistake?
Yeah. Jane's paid.
Hi. Oh my gosh.
Sorry.
Oh my gosh, Shannon, how are you?
I am
It's
good.
so
I
good
thought
to
you
see
had
you.
retired.
Oh God, I probably should. People are all.
Are you up here now?
Yes.
Oh. Really?
Oh, Jesus. Remember when I was up here? Were you here?
Oh my gosh, you
Yeah.
were with Pickard
No,
or Glazier.
We touched Glazier, yes.
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 Wow, we're going back here.
A long time. You were with Travis, weren't you?
Probably, yes.
Probably, yeah.
Oh my gosh.
I remember. Oh, it's so.
Yeah.
I miss you. I'm
Aw.
glad to see you.
Well, it's good to see you.
Thank you.
Take
gosh.
care.
Take care. Bye-bye, senior. Hi, Justin. Hi.
How you gonna do it? There is no way. I could try to repeat that all over every single day. Yeah. Yeah.
Hey, Ms. Underwood, can we go in a breakout room?
No, when I was like 18 to 20, I worked for Travis Ballard as a receptionist. So, and I don't know, I just kind of stayed in contact with a lot of the courthouse people who see him. I worked at a bank for 25 years, so I would see him there. And I've had my own son come through the system. So, so yeah, one way or another, we kind of kept all in contact, so sometimes we go years without seeing each other, or sometimes not. But today, I'm just here for another mom that couldn't be here for her daughter, and I just texted her and said, 2+ hours later, and I'm still sitting. Calling me. What else? And I was a few minutes late, and gosh, I sat here for 2 hours. And I've already called her, and I missed it. So I went online, and it still showed she was scheduled today, so I was hoping I didn't miss her.
You have to give it to me.
I tried to, but you're doing it.
Okay.
I got it.
All right, just forget it.
Ooh. Oh, you can take care of yourself, you know.
Oh.
What do you agree about? Just get up, we're late.
Anyway, great jacket.
Put your jacket on the table.
Miss Underwood,
Yes, Aaron, we'll be in court in a minute.
all right. The bus, I didn't know if I can get my bond
Um,
lowered. It's at like 80,000 right now. I can't afford no 80,000.
Aaron, don't talk, please.
All right, please, third court's now in session. Maybe seated.
All right. So, let's see what we got. All right, let's see. Close the jail room. All right, so Mr. Glazier, I got Joanne, yep. What was that you just told me a few minutes ago, Ms. Fay? Say it again.
You were right regarding the forensic.
Okay, thank you. I just wanted to be known that Joanne Spade said I was right about something, because usually I'm not, but I'm just really proud of that. So this is in the matter of the people of the state of Michigan versus Maria Rodriguez. So Mr. Glazier, have you had a chance to talk to your client?
Yes, I have, Your Honor. She's going to enter a plea of guilty to, I think there's 2 counts, and she's pleading guilty to the possession of, I think it's cocaine, and the possession of meth, and any, I don't know if there's habitual, but any habitual be dismissed at the time of sentencing. She'll also plead to the contempt of court, Your Honor.
All right, so she's going to plead guilty to count 1, possession of meth.
No, count 2. I think it's count 2.
So she's only pleading to count 2, possession of cocaine.
Yeah, with count 1 and the habitual be dismissed at the time of sentencing.
All right, and Mr. Sneed, is that the plea offer? You're muted. I'm sorry.
So yes, count 2 is the offer, Your Honor.
Okay, thank you. All right, so, all right. Okay, so Ms. Rodriguez, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, I'm gonna need you to speak up a little bit again. Can you say that again?
Yes, Your Honor.
Thank you. All right,
You're
so
welcome.
Ms. Rodriguez, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention that you're gonna plead guilty to count 2, controlled substance, possession of cocaine, which carries a maximum penalty of up to 4 years in prison and or a $25,000 fine?
Yes.
All right, and then you're also going to plead guilty to the contempt of court for failure to drug test 3 times a week as ordered. Is that correct?
Yes, Your Honor.
Okay, and I'm going to dismiss, I'll dismiss the failure to appear one. Okay, so Ms. Rodriguez, are you satisfied with your attorney and the advice that he has given you?
Yes, Your Honor.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Glazier?
Yes, Your Honor.
Mr. Sneed?
Yes, Your Honor.
Is there any referral to recovery court at all on this file?
You know, I didn't ask for that, Your Honor, but have you ever done drug court before?
No.
Yeah, why don't we have her screened for that, Your Honor?
So Miss Rodriguez, we do offer a specialty court, recovery court, that deals with people who have substance abuse health issues. Would you like to be screened for it?
Yes, Your Honor.
All right, so Mr. Glazier, will you submit the request to screen?
Yeah, I can do that.
All right.
Thank you, Your Honor.
Okay. Did you say something, Ms. Rodriguez?
Thank you, Your Honor.
Okay, good. Thank you. You're welcome. All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Glazier?
That's correct, Your Honor.
I think I already asked this. Mr. Sneed and
Yes, sir.
and Ms. Rodriguez, is that correct?
Yes, Your Honor.
All right, so Ms. Rodriguez, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, ma'am?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen, if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've just given to you? All right, so Ms. Rodriguez, how do you plead to the charge that on or about March 30 of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense of controlled substance, possession of cocaine less than 25 grams, guilty or not guilty?
Your Honor.
Okay, and you said guilty, right?
Yes, Your Honor, guilty.
Okay, I think it's the room, and you're kind of far away. If you can scoot up a little bit, that would help. I'm so sorry. It's not your fault.
Okay, sorry.
And then, ma'am, how do you plead to the contempt of court that you failed to drug test 3 times a week as ordered, and you failed to do so since June of 2024? Guilty or not guilty?
Guilty, ma'am. Your Honor.
Right. Yep. Has anyone made any promises or threats to you to induce you to plead guilty to these charges?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier?
No, Your Honor.
Mr. Sneed?
Sorry, no, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be, Mrs. Red? God bless you. All right.
Sorry.
It's okay. Has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
All right. Is it your own choice to plead guilty?
Yes, Your Honor.
All right. So, ma'am, on March 30th of 2024, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
And at that time, did you have in your possession the controlled substance cocaine?
Yes, Your Honor.
Did you have any legal right to possess that?
No, Your Honor.
Would you agree it was less than 25 grams?
Yes, Your Honor.
And you know it was cocaine?
Yes, Your Honor.
Mr. Sneed, any additions?
No, thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Glazier?
Yes, it has, Your Honor.
Mr. Sneed?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. I am going to set sentencing for December 13 at 8 8:15 in the morning. Ms. Rodriguez, do you want to appear via Zoom or in person?
That would be good.
Okay. And your bonds continued. Anything else, Mr. Glazier or Mr. Sneed?
No, thank
Your
you.
Honor, is her bond a PR bond with testing?
No, because she didn't test or show up. So she's
Well,
got a
that's what I-
25,000 cash
Yeah,
bond.
I guess I'd like to address bond then. Did you want to do the plea on the contempt of court also, or?
Already did.
Oh, you did? I wasn't paying attention. Could I address bond, I guess, Your Honor?
Okay.
Your Honor, I don't know why my client didn't show up or didn't set up for testing. I guess she can explain that to the court. We'd ask her to give her another chance to get out and, testing regularly or randomly, however the court wants to do it. And I am gonna ask that she be screened for drug court. I'll get that letter sent over. But she doesn't have much of a record. I think her other prior is a drug charge. You're looking at the habitual. I don't know what she has besides that, but she just wanted to see if I could ask for a PR bond with the testing, and she'll make sure she gets it done.
All right. Well, I guess, so Ms. Rodriguez, you were ordered a drug test, correct?
Yes, ma'am.
And you didn't do that, did you?
No, ma'am.
Is that because you were using?
No, so I was homeless and I didn't know where to go, so I decided to go to Toledo with my uncle. And I couldn't come every day back and forth.
Mr. Sneed, would you like to address the request for PR bond?
Your Honor, I would defer to the court's discretion here. Thank you.
Judge, she
Mr.
did test on May 31st and she was positive for meth, cocaine, and also amphetamines. I also spoke with district court back on August the 5th. She actually walked out of the courthouse when they told her not to leave. I've tried calling her numerous times to get her to test, and she would never call me back. So her track record for doing testing is not good.
All right, I'm gonna deny the bond request. I'll continue the bond I will change it to 25,000 cash as surety instead of 25,000 cash. We will screen her for recovery court. So Ms. Rodriguez, someone from the probation department is going to come meet with you. It's important that you be very truthful about your addiction history, also your background and the events that occurred. They'll prepare a pre-sentence report. We'll get a copy of that to Mr. Glazier. Mr. Glazier will review that with you before sentencing, and we'll see you back on December 13th at 8:15 via Zoom, okay?
Okay, thank you.
Thank you, Ms. Rodriguez.
So you don't think I need her address or phone number?
Nope. Nope.
Okay. You said December 13th?
Yeah. Ms. Rodriguez, if by some chance you postpone and get out, you need to immediately report to the probation department on the 3rd floor, okay?
Okay.
And if you do get out, you need to also report to see Mr. Coast on the 3rd floor to set up drug testing, okay?
Okay.
All right, those bond conditions would be continued if you were postponed. All right,
So on
you're
the
all set,
13th?
Ms. Red.
On the 13th, I'll get sentenced?
Yes.
Okay, thank you.
All right, thank you.
All right. Thank you,
Okay,
Your Honor.
all right, Mr. Dagmar-Gosian, have you had a chance to talk to Ms. McClure about Mr. Edwards?
Judge, we handled Mr. Edwards. I just need to be in a
Breakout room with Mr. Oliveras.
please, Your Honor. Thank you.
Okay. Meet Mr. Oliveras is in 5. All right, so Mr. Oliveras, thank you for being so patient this morning. And I'll pop you in that waiting room. All right, so I have a young lady with brown hair. What's your name? Shannon Heatherly?
Okay.
Okay, Miss Underwood? If not, all right, and the young man in jail Zoom 6, what's your name?
Lindeman.
Lindeman. Not Mason.
Oh, no, ma'am.
All right.
Can I be in a breakout room with Miss Underwood or Darren Coast?
Hold on a minute, because I haven't called your case yet, so I need Miss Underwood. She is probably zooming in another court right now. All right, so I'm gonna go through my, nope, there she is, she's coming. I'm ready. Do you want to zoom in or?
No, I can do it from here.
Okay. All right, and I have Miss Heatherly too. All right, so I'm gonna grab Mr. Lindemann's file, and I have Miss Heatherly too.
Or I might need to speak to.
Okay. All right, this is in the matter of the people of the state of Michigan versus Aaron Scott Lindemann, file number 24-21941 FH, 24-21864 FH. I have Rhonda Underwood appearing on behalf of Mr. Lindemann. This is the date and time set for pretrial on both of these files. We also have a contempt of court on each file for failure to appear on October 2nd of 24 and failure to do drug screens. So we have that and the pretrial. So Miss Underwood, Mr. Lindemann said he wanted to talk to you.
Oh, okay, but I spoke to Mr. Sneed yesterday, and I spoke to Mr. Lindemann yesterday about this, and what we want is a short adjournment, perhaps to the 13th, Your Honor, and then I would like to address bond on Mr. Lindemann's behalf.
Okay, so you're asking for an adjournment to November 13. Any objection to that, Mr. Sneed?
No objection to the adjournment.
All right, that'll be at 8:30. You can do the stip in order to adjourn. Mr. Sneed, can she sign your name with permission?
Yes, thank you.
And yes,
Judge, I can take care of that. It's a probation case.
oh, never mind.
I'm sorry, never, disregard. I was looking at the wrong case.
Okay, so you'll do the stip in order to adjourn. So you can address bond.
Your Honor, Mr. Lindemann is in a very different place now. He has had time to reflect on what happened. He understands the need for bond and for conditions, Your Honor. He would be happy to comply with any drug conditions the court added and a tether, Your Honor. He would be happy to do things. They would allow him to get out, to go to work, and to continue his life, Your Honor. We would ask that the court consider bond with whatever drug conditions with Mr. Coast the court allows and a tether, Your Honor, in this matter.
Okay, so I can't hear you, Mr. Lindemann. What'd you say?
I got a job interview for Friday. It was supposed to be for Monday, but I can probably get my job interview back for Friday.
Okay, so Ms. Underwood, in this case, Mr. Lindemann failed to drug screen on September 17, September 19, September 24, September 25, and September 30, or anytime thereafter. He was arrested, so he's been in jail a couple days. So I'm glad he's had a couple days to reflect. Mr. Sneed, any position?
The people would like a bond to remain, Your Honor. Based upon the seriousness of the charges, Mr. Lindemann's facing a 2-year mandatory minimum for the felony firearm, which he brandished a firearm at a police officer. That was while he was out on bond, Your Honor. So on a prior charge. So I'd like the court to consider that and possibly increase bond if the court deems that's appropriate. Thank you.
Your Honor, first, let me very much object to that characterization. And Mr. Sneed knows it. That is not what happened. And
you play the video.
I'll use my.
No, I'm fine. And those are allegations. Obviously, he hasn't pled to anything. So I understand. Because he's failed to appear and failure to test, I am not comfortable releasing him on a PR bond at this time. His bond is currently set at 25,000 cash total. But I am going to set his bond at, let me see on both these files. I'm going to set his bond on each file for 30,000 cash surety on both files.
Is that 15 on each?
15,000 on each. And we'll make that change. 30,000 on each file, cash surety.
I thought it was 15 on each file.
No, 30,000 cash surety on each file. Obviously, Mr. Lindemann, if you post bond, you need to report to Mr. Coast immediately. Set up tether.
So how much is my bond?
You'd have to post, well, it's 30,000 cash surety. Is that a, Mr. Steen, I guess I gotta ask you, is that a suitable amount for bond or no?
I would defer to the court's discretion. I thought the court said at 30,000 per file.
On cash surety, yes. I guess I'm just asking if you have any objection to that.
No, thank you.
Okay, so it's 30,000 cash surety on each file.
So how much is that? 10%?
Of 30,000, that'd be
Yeah.
3,000 on each file.
I think that's 6,000.
Isn't that what it was?
I don't know,
Isn't that what it-
but that's
I
what your
just said
bond
it,
is.
though.
Okay.
Ms.
So,
Underwood? Isn't
your
that what my
bond was-
bond just was?
I don't,
60,000?
your bond, I set it at 25,000 cash. So your bond was revoked by the prior bond, by 24/7 bail bonds revoked your bonds. So no, that's not what your bond was. So you would have to repost your bond. Because the bonding agency revoked your bond.
Oh,
Okay, all right, thank you. You're all set, Mr. Lindemann.
can I be in a breakout room with Miss Underwood?
Ms. Underwood has one more client after that. Do you have time to meet with them this morning? You gotta go back to Judge Olsaber.
I think I have Mr. Lindemann over and Judge Olsaber.
Okay, she will not have time to meet with you this morning, but she will get over to meet with you, okay?
All right, thank you.
Thank you. Okay, so can you take care of Miss Heatherly? You need to talk to her.
I need to speak with her.
Go back there and we'll put you in a breakout room with her. Mr. I'm thinking Mr. Daggermar goes in. I think I just heard doors close. There he is. Okay, so. All right, hold on one second. Okay, this is in the matter of the people of the state of Michigan versus Castro Cash Oliveras. We have two files, 24-21891 FH, 24-21892 FC. I have Dave McCready appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Mr. Oliveras. So this is the date and time set for, it's a pretrial conference. So Mr. Dagger Margosian, how do you want to proceed today?
Your Honor, Mr. McCready and I have been talking about this case. We're not at this point able to resolve it. I'm asking the court to schedule both these matters for a jury trial. I'm obviously happy to continue to speak with Mr. McCready moving forward, but that is my request at this time.
All right. Okay, so these cases would not be tried together. Is that correct?
Correct. That would be correct.
So the FC file would go to trial first. Correct?
Yes.
Thank you, ma'am. All right, Miss Underwood, I'm going to put you and Miss Heatherly into a breakout room. Take your time. There you go. Go ahead and join it. Okay, how many days, including deliberations, do you need for 24-21892 FC trial?
I would say 2 days, maybe 3 if the deliberations go very long.
Mr. Degemer, okay. All right, so. Ms. Adams, have the attorneys on Blake or Massick contacted us about the dates that I gave them?
They have not, Judge.
Well,
I think there's a hearing October 28th on that.
so I have a civil jury trial in December that the attorneys are trying to move. And I'm probably gonna let them move it. So that means potentially I could have December 16, December 17, and December 18 available.
That works for me.
Mr.
That works for me.
McCready?
That works for me, Your Honor, yes.
I usually grant those requests. In the event, so I'm gonna set this for a 3-day trial. File number 24-21892 FC, starting December 17. Right. Tuesdays start at 9 a.m., Wednesdays start at 10:30, Thursdays start at 9 a.m. I do a December 17th trial date. I'm going to set a final pretrial for November 27 at 8:30 in the morning. I'm going to require that jury instructions and voir dire questions be provided to the court by November 20th. I apologize that they have to be that early, but I will be out of town for a conference for a week in December. So kind of sets my dates off. And motions must be filed and heard by November 27 of 24. And I will set for pretrial also on that date, 24-21891 FH as well. So,
what was the pretrial date on that?
November 27 at 8:30.
Oh, okay.
I don't have a deadline on pleas, so that's not an issue. All right, I have filled out the scheduling order. Failure to comply with it obviously is detrimental. And anything else, Mr. Degemer?
I don't think so, Your Honor.
Mr. McCready? Mr. McCready, anything else?
No, nothing else.
Okay, all right. You're all set, Mr. Oliveris. We'll see you back then, all right? Obviously, if some resolution is reached, you can bring them in sooner. All right, thank you, Mr. Oliveris. All right, so, let's go through. Attorneys, penalties and waiving. Ah, you're back in court. You're quiet. All right, let me get Miss Heatherly back. All right, she's back. All right. Okay, we are on the record in the matter of the people of the state of Michigan versus Shannon Marie Heatherly, file number 23-21248FH and 23-21249FH, as well as 23-21250. FH. I have Rhonda Underwood appearing on behalf of Miss Heatherly. This is the date and time set for a violation of probation pretrial. And so, Miss Underwood, how do you wish to proceed today?
Miss Heatherly wishes to plead guilty to the violation of probation.
Okay, and then there is contempt of court for failure to appear for the probation violation.
Guilty to that as well.
Okay. All right, so Miss Heatherly, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, so I have no audio on you. Can you scoot up a little bit?
Yep. It's better?
It's very bad in that room.
All right, now can you say your response?
I do, Your Honor.
Okay, perfect, very good. Just make sure you keep your voice up. All right,
Okay.
so Miss Heatherly, we are here today on 3 different files and a violation of probation on each of these files. The allegation on each of these files is that you violated the terms of your probation and that on May 25 of 2023, you were ordered to report as often as required. You were then ordered to report on April 19th of 2024 to report immediately after being discharged from Dawn Farms residential treatment. On July 22nd of 2024, Monroe agent Christine Lindsay was notified that she left treatment without successful completion on June 5 of 2024 and has failed to report on that date or any time thereafter. Do you understand that?
I do.
And then we mailed to you a request and summons for probation violation with those allegations, and we set it for a hearing and then a trial on September 5 of 24. Do you understand that?
I do, Your Honor.
And you failed to appear on that day. That's the other allegation. Do you understand that?
Yes, ma'am.
All right, and according, your attorney advises you wish to plead guilty to those violations. Is that correct?
That's correct.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, ma'am.
All right, so on file number 23-21248FH, ma'am, if you enter this plea, do you understand the maximum penalty could be up to 5 years in prison? Do you understand that?
I do.
And on 23-21249FH, if you enter a plea on that file, do you understand the maximum penalty could be up to 4 years in prison? Do you understand that?
Yes, ma'am.
And then on file number 21250FH, you had pled to uttering and publishing, which means if you plead guilty or found guilty, you could be facing up to 14 years in prison. Do you understand that?
Yes, ma'am.
Okay, so Ms. Heatherly, you understand that you have a right to contest these violation of probation charges and to have a trial on them?
I do.
Do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes, ma'am.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
Yeah.
Say it again a little bit louder.
Yes, ma'am.
Okay, good. You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
I do.
How do you plead to the charge that you violated the terms of your probation by failing to report upon discharge from Dawn Farms and leaving the program without successful completion on June 5 of 24, and then failing to report to probation anytime thereafter? Guilty or not guilty?
Guilty.
And how do you plead to the charge that you failed to appear for the probation violation hearing on September 5 of 24?
Guilty.
Okay. Do you understand by pleading guilty, you'll be giving up your right to a trial, as I've already explained to you?
Yes, ma'am.
Has anything been promised to you to get you to plead guilty?
No, ma'am.
Has anyone threatened you in any way to get you to plead guilty?
No, ma'am.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats. I'm so sorry. That were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, I do.
Is it your choice to enter a plea on these 2 counts?
Yes, Your Honor.
All right. So Ms. Heatherly, you were placed on probation and you were ordered to enter and complete Dawn Farms residential treatment program. Is that correct?
Correct.
I believe that was an order from district court, Your Honor.
Okay, but you were ordered to enter and complete that program, correct?
Yes, ma'am.
All right, and then did you leave that program without successful completion?
I was asked to leave. It was a mutually decided. I wasn't getting what I needed from them, and they didn't think it was a good fit. And I do have a letter from
right.
my therapist. So, but yes.
So you didn't successfully complete it, right?
No.
Okay. And you're supposed to report to the probation office, and you did not report to the probation department after you left Dawn Farms. Is that correct?
That is correct.
We mailed to you a notice, a request and summons for probation violation, and you entered a plea of not guilty, and I think you got set for a trial, and you were supposed to appear for the trial on September 5 of 24, and you didn't appear. Is that correct?
That's correct.
All right. I accept the plea. It has been the pleas. They've been given understandably, voluntarily, and accurately. She has full knowledge of her rights. She does have competent counsel. I'm going to refer this matter to the probation department for a pre-sentence investigation. And I'm going to set sentencing for October 25 at 8 a.m. Miss Heatherly, do you want to come in person or via Zoom?
Zoom's fine.
Zoom is fine?
Yes, ma'am.
All right, so I will set that via Zoom. Ma'am, did you say you were here for Heatherly?
Yes.
Are you her family?
Friend of the family, yes.
Okay, so I just wanted you to know you do have people here in the courtroom that were here to support you. So, all right, we will see you back when you meet with the probation department. Be truthful about what's been going on with you, and they'll update your pre-sentence report, and we'll see you back on next week at 8 o'clock. All right.
Okay, thank you.
Thank you.
Your Honor, can I ask? We have a couple names, Nicole Quinones and Lee Byers. What happened on those?
Oh, they didn't show up. They didn't show up.
Oh, so was the bench one?
Oh, yeah.
Okay, and do we have an extradition with Mr.
He waived.
Granberry?
Yeah, he waived it.
He waived.
Yep. So I believe,
My docket with you is complete.
yes, it is. Thank you so much, Ms. Underwood, as always.
Thank you.
Okay, so now sir, what are you here for?
Judge, they're here for, in support of Miss Bannon.
Okay, because I was like, they've been here all morning and I'm like, did I miss their case? Okay.
They're here with me.
Okay, so Mr. Dagger Margosian and Miss Muir, did you guys want to talk to me?
Nope, so we're actually two halves of different holes. So he needs Mr. McCready and I need Mr. Glazier.
Mr. Glazier's in the hall.
Mr. Glazier's in the hall?
Yes, and he's the one who wants to talk to you on Haybecker.
So
they have a restitution hearing with Mr. McCready and Dave said he was running a few minutes late.
okay, so why don't you get Mr. Glazier
Okay.
and we'll go in the jury room.
We can do that.
And that is what case?
Haybecker.
Okay. Way too many files. Why do I have this many files? Miss Jody Morris. Why do I have a file for Jody Morris?
That's the restitution.
Okay. But I did do counties. Okay.
So Mr. Glazier
I'm gonna go
talked to his client. You want me to just grab him?
Yeah, you can just grab them. I gotta take this stuff, this add-ons. And I'm gonna take this. She's ready for that. I'm gonna take this.
Straight better. Just have a seat.
Yeah. Back to the story. Thanks.
Vehicle. Just like, I don't know. No, oh, that's interesting. No, like, must have really, I don't think this would be simple, whatever, it's what he did, his investigation proceeds to have this restitution. That's what. No. I guess that seems like that's how. So, yeah, definitely the amount, but you're right, yeah, I guess you're right, yeah. So, and she. Then, so. Right. Right. They don't, you can use the force of one. Yeah. So. Whatever. Oh, yes. I haven't talked with yeah. And he will. Oh, he said that. No, he just said, he said, so I know. But I mean, if you want to talk with you guys. Oh.
All right, please. Mr. President. Be seated.
I don't know why the whole building smells like chili, Mr. McCready. I have to actually remove everything from the bathroom up here because the vent goes straight up. And one time you guys had popcorn party and my room smelled like popcorn.
Especially microwave popcorn.
Mhm. No, I think they did in the. Okay, so this is in the matter of people of the state of Michigan versus Jody Lynn Morris, file number 23-21637FH. I have Dave McCready appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Jody Lynn Morris. Do you have Miss Morris?
She's in absentia, but I think Mr. McCready and I wanted to approach anyway.
Oh, okay, I'm sorry.
So I think it's peanut institution. They talk on the phone here. So at this point, she's sentencing. Institution at this point, she can come forward.
Okay.
Somewhat needed time to establish.
Well, sentencing is not till December 13th. You guys decide you want to reschedule. You can do that.
Yeah, I mean, I think it's at this point. And shade, restitution just.
Yeah, I mean, she can obviously provide as part of her victim impact statement. Here's the PO that was assigned to this. No, we just. Yeah, okay, that's fine. So we'll just continue this to sentencing. All right, so.
Well, I guess one thing, Judge, she does provide a victim impact statement.
You still have the right to restitution.
I guess.
We could always adjourn the sentence.
Sounds.
Okay. All right. So, in this case, this restitution hearing will be adjourned without date because we're not sure whether or not we'll need it at this point. Sentencing is scheduled for December 13 of 2024. If at that time, the victim in this case does supply information for restitution purposes, I can adjourn that sentencing to have a restitution hearing. All right.
Thank you.
All right. Thank you both. All right. So, so can I ask what you're here for?
For eviction.
So, do you want to take them down to district court maybe? So what's your name?
Opal Thomas.
Okay, so I'm gonna guess you're supposed to be in district court. So I'm gonna get off the bench and my bailiff's gonna show you where to go, okay?
Oh, I thought I was supposed to come back here.
Huh?
And it was a 10:45. I come to the wrong place.
So we're just waiting for Mr. Glazier. Okay. Get this. Go shoot your. Oh.
I think they'll do that. Yeah.
Right.
Chilling down there, because I can smell it up here.
The judge said her chambers. smells
I can smell it here. We just have crack. going on. And
I can't. I'm gonna check before it's time. You got any vacations planned or anything?
yeah, we're doing like a group vacation down to the Dominican in December.
To where?
Dominican,
Oh,
so I'm kind of waiting for that.
you probably don't smoke cigars. That's a good place to smoke cigars.
No, but most of the group does.
I'm going to Pennsylvania for probably 3 days next week for the colors.
Oh, that'll be nice.
There's a state park up there. It's called Ohio State Park.
Oh, I've heard of that.
And they got whitewater rafting. It's got a waterfall. It's got these rapids.
Are you gonna do that?
No, but we can sit right there and watch it.
Watch them do it? That's
I mean, it's right next to the rapids.
That's
It's
cool.
kind of cool.
Yeah.
We did it last year,
Is it a long drive?
about 6 hours. Then
It's not too bad.
Yeah, and then about an hour south from where we'll stay at a hotel.
Hmm.
It's right up in the Laurel Highlands. About an hour. They also have at the same spot where we are, they have Falling Water, the home that was made by one of the real famous architects. From Wisconsin. He's got Frank Lloyd Wright.
Oh,
And it's a house where the waterfall comes behind the house, flows under the house, and then comes out.
that's cool.
And I've never been inside because it's only open on like weekdays. But I think there's floors where you can see the river going right under the house. It's a real famous one. So, but you can see it from the outside. It's pretty cool. Donegal, Pennsylvania. There's also there's a port up there when George Washington first became well known for a battle up there.
Do you take your kids or just you and your wife?
Usually kids, but I don't know how many will go this time. We've become familiar with the area because we used to stop there on the way to North Carolina all the time.
Oh,
And that's how we got to know the area.
when are you going down there again?
We usually go down there in August.
Oh.
We've gone all different times, probably the last 10 years. It's August. Well, excuse me, it's July. We do it around the 4th of July because August you can get hurricanes.
Yeah.
And we've got removed a couple times because of hurricanes. So we kind of do that on the 4th of July, the week after usually.
Please rise. Report off session. Joanne?
Okay, I guess we need Joanne. You can be seated. I'm sorry. No problem, Judge. It's fine.
Oh, we're waiting for her.
Just me. Mr. Haybecker, you might come sit up by your attorney. Okay, so this is in the matter of the people of the state of Michigan versus Anthony Scott Haybecker. We have 3 criminal files, 24-21819FH, 24-21818FH, and 24-21817FH. We also have a PPO file, 23-51303PP. So, Mr. Glazier, we had an opportunity to have a bench conference with Ms. McClure. I have received a plea agreement form. So, Mr. Glazier, how would you like to proceed today?
Your Honor, I'd ask to adjourn this maybe 3 or 4 weeks at the longest. My client, I think we're closer than what I led the court to believe when we were back in chambers. I got to go over some things with my client. He wants me to subpoena some records, which I will do. And hopefully we can get this matter worked out. If we don't, we'll set it for trial at the next pre-trial. In regards to the PPO, if we could adjourn that as well. The one questions we had was about the 3 counties, and there was some talk with his prior counsel about amending those. And as I discussed back in chambers, he does have a brother that lives in one of those counties. And he also has treatment and some other stuff that are going on.
I'm alumni of the Bear River Health up there, and
I can't hear you.
I'm sorry.
Speak up.
I'm alumni of Bear River Health rehabilitation up there. It's for substance abuse, and it said after a year being sober, and I've been sober since September 15th of last year. I'm actually grateful what occurred as far as with the.
Okay, I don't care about any of that. Hold on, I'm gonna stop you talking now. I don't care about any of this at the point because we're not amending his bond conditions.
Yeah, I think what we're gonna ask is also to amend it to allow him to go up for mental health and substance abuse treatment
in church.
No, I don't know. Ms. McClure?
We would oppose it.
Yeah, I'm not gonna agree to that at this point. Okay, so the problem is we have his motion to modify the personal protection order, but we potentially have a violation of that PPO?
I believe the violation itself has been taken care of, but the motion to modify has not. And I could be wrong on that, but that's my understanding.
That's what we were asking, Judge. I want to get specifically what he goes up there to do.
But I think that was part of a plea offer, and if he doesn't plead, that doesn't happen yet.
I understand, but then his motion to modify the bond, I guess we just asked to adjourn that so that I.
Yeah, I'll adjourn that as well.
What he wants to do, you know, what he needs to do up in one of those counties or those counties.
So he wants you to subpoena records, is that for what?
I don't know what those are, but we didn't have a time to discuss that. So that's something I told him, comes to my office and I'll get the subpoenas out. I usually get stuff back pretty quick.
Okay. All right. So again, I do have the email from Mr. Coast verifying that he hasn't violated anything on his tether. But he made this Facebook post which mentions a minor child of the alleged victim in this case, and then talks in general terms about the victim in this case, kind of in an offhanded way. Mr. Haybecker, do you understand those words do not come out of your mouth? You don't talk about her 4th cousin twice removed, her children. You don't mention anything to do with those people. Do you understand that?
Yes.
Because I don't care what happened at the jail. I will put you in jail again. Do you understand?
Yes.
Do you have any questions about that?
No.
You fully understand your bond conditions? If there is another violation, I would ask for a warrant and I will just issue a warrant and I'll remand you. Do you understand? You don't even breathe their names. People do not deserve to live like this. Do you understand that? She doesn't want to talk to you. She doesn't want to hear from you. You're not going to get that opportunity to speak with her. Do you understand?
That's fine.
Anything else other than a date?
Just a date, and then, as Mr. Glazier indicated, if there is no resolution at that time, both of us would be asking for a trial, and I would just ask him to consider ahead of time a stipulation to consolidate these cases for trial, just so we can address that at that time, and I know whether to file an answer or not. But again, no answer today, but just at that time we set trial if necessary.
So Ms. Adams, I'm going to need a notice of hearing from Mr. Haybecker today. I'm sorry, I know it's coming into your lunch break. I'm going to set this over to how many weeks, Mr. Glazier?
Like 3.
November 6th at 8:30 in the morning. Are you available that day, Ms. McClure?
Yes.
It's probably a Wednesday. Is that a Wednesday?
Always a Wednesday.
It's like, we're out of
All right, so don't leave yet. I'm gonna get him a notice. So that way he'll have the notice. All right, and that'll be at 8:30 in the morning. And I'm gonna ask that you all leave first, the building. And you're gonna stay here about 15 minutes, all right?
When does Miss Spate get a leave? Is the question.
What?
When does Joanne get a leave?
Joanne does whatever Joanne wants. All right, okay, so November 6th at 8:30, and we will get you, do you want to do it like 10:30? Let's do 10:30,
Okay.
just because Mr. Glazier goes to Judge Olsaver first.
Yeah,
Not
in case.
necessarily.
Usually,
I can go here first if you want. It doesn't.
oh, no, I get Sam and Matt.
I usually go to Judge Olsaver.
We have a procedure. You and Michael go there first, and Sam and Matt come to me first.
Nobody's
Don't
told-
change it. Don't.
nobody's told me that was a procedure.
You agreed to it.
I probably Mike did. I didn't.
Okay.
Probably said my name to it.
All right, and then you wait for your notice of hearing, and you can leave the building at about 12:15.
We're already running a little bit long.
I don't care. 12:15.
How are they in?
No, 12:15. You don't leave the building to 12:15.
Okay, thank you.